A five-judge constitution bench of the Supreme Court today struck down the Maharashtra State Reservation for Socially and Educationally Backward Classes Act 2018, stating that the particular act did not meet any exceptional circumstances for granting the reservation in public and educational employment opportunities to the Maratha community. The court categorically held that the state government had failed to establish any exceptional circumstances for granting the 13% reservation to the Maratha community and breaching the 50% ceiling laid down by Indira Sawhney. The court also rejected the argument of the state of Maharashtra, which said that Indira Sawhney needed a relook and a reference to a larger bench judgment. Justice Ashok Bhushan stated that the state of Maharashtra could not satisfy the court that Indira Sawhney needed a relook and that it should be referred to a larger bench. The court has held that Indira Sawhney has been at least followed by four constitution benches of the Supreme Court. The Supreme Court today also upheld the 102nd Amendment to the Constitution and stated that it does not violate the basic structure of the Constitution. Justice Ravindra Bhatt, in his separate concurring opinion today, noted that it is only the President alone empowered under Article 342A of the Indian Constitution who can notify the socially and educationally backward class list, and that the state governments can only merely suggest the precedent for inclusion of this particular caste under the SCBC list. Solicitor General Tushar Mehta had today mentioned before Chief Justice of India N.V. Ramana that the central government was challenging the Delhi High Court order of yesterday, wherein the court had called upon the officers of the central and state governments to ask whether or not contempt proceedings can be initiated against them, since they had not met the Supreme Court-led target of 700 metric tons of oxygen supply to Delhi in the face of the second wave of COVID-19 pandemic. An urgently constituted bench of Justices D.Y. Chandrachud and M.R. Shah heard the case. Solicitor General Tushar Mehta apprised the court that the central government had formulated an expert panel to see how much supply of oxygen is actually needed by each state. As per the expert panel report, the Solicitor General submitted before the court that Delhi does not need 700 metric tons of oxygen. However, Justice Chandrachud stated that people were suffering and that supply of oxygen was not only confined to the number of beds in the national capital of Delhi, and it was also because thousands of patients were waiting for oxygen outside hospitals' beds even. The court has now asked the central government to apprise the court tomorrow morning at 10:30 as to the plan, as in how 700 metric tons of oxygen can be made available in the national capital of Delhi, especially the supply chain from where the 700 metric tons of oxygen would reach Delhi. The court has also asked the central government and the Delhi government officials to convene an urgent meeting today evening to sort out the supply chain issues with regard to the supply of 700 metric tons of oxygen. The top court clarified that it cannot reduce the quantity as specified in its April 30th order because the other judges, Justices Ravindra Bhatt and L. Nageshwara Rao, were not in the bench, and that it was a matter of deference for Justice Chandrachud to not reduce the quantity as decided earlier. However, the Supreme Court today stayed the contempt notice issued by the Delhi High Court and stated that hauling officers for contempt would not solve the problem of oxygen in the national capital of Delhi. It has also stated that the stay of the contempt notice will in no way mean that the Delhi High Court cannot hear its suo motu COVID-19 case and other related issues. The petition seeking a halt on the Central Vista redevelopment project was today mentioned before Chief Justice of India N.V. Ramana-led bench. Senior Advocate Siddharth Luthra mentioned the appeal against the Delhi High Court order of yesterday, wherein the case was adjourned to May 17th without issuing notice to the petitioners. Though CJR Ramana hinted the case to be placed before the Delhi High Court again, Senior Advocate Luthra stated that the ASG was comfortable with a May 10th hearing. However, the High Court needed time to peruse the Supreme Court judgment, which gave a go-ahead for the Central Vista redevelopment project. The petitioners have made it clear that they are not seeking a review of the Supreme Court judgment, which gave a green signal to the project, but instead sought a temporary halt to the construction activities, since the movement of laborers and construction activities in that particular area would wreak havoc on the health system in the peak of the COVID-19 pandemic. The matter is likely to be heard tomorrow. Well, that's all from Supreme Court today. Do stay tuned with Supreme Court Today tomorrow as well. And don't forget to like and share baranbench.com.